Karen. Rules Committee will come to order, and thank you very much for joining us this evening. Today, the committee will consider House Joint Resolution 40, House Joint Resolution 41, and House Joint Resolution number 38. H.J.Res 40 utilizes the Congressional Review Act to overturn the implementation of a rule published by the Social Security Administration that prohibits individuals from purchasing firearms and explosives. The SSA rule discriminates against individuals with disability by denying them their Second Amendment rights and deprives them of their right to due process. Targeting this population for placement on the NICS registry will, I think, not make America safer, and certainly not those individuals. Instead, it punishes and stigmatizes individuals for getting help with managing their benefits. Look forward to reconsidering this measure, as I have heard directly from constituents, a number of constituents, for a long time about this rule. The second joint resolution under consideration, H.J.Res 41, disapproves the rule submitted by the Securities Exchange Commission related to disclosure of payments by resource extraction issuers, which was published by the Federal Register on July the 27th, 2016. The SEC's resource extraction rule applies only to U.S.-listed company and does not require private nor foreign state-owned entities to file these mandatory disclosures. This puts U.S. companies, some of which are in my home state of Texas, at a competitive disadvantage to their state-owned competitors, especially considering the estimated cost for compliance, which range from $239 million to $700 million in initial compliance cost and $96 million to $591 million in annual ongoing compliance cost. The third and final measure that we will consider today, H.J.Res 38, utilizes the Congressional Review Act to overturn the Office of Surface Mining Reclamation and Enforcement Final Stream Protection Rule. OSM produced the final rule without input from states responsible for enforcing federal mining regulations and disregarded existing regulations on both the state and federal level that have proven effective. This joint resolution protects hundreds of thousands of jobs nationwide by cutting red tape directly threatening the nation's coal industry and workforce. Additionally, by overturning this final rule, the joint resolution ensures home energy prices do not unnecessarily rise and harm consumers. Before we welcome the gentleman from Virginia, Chairman Goodlatte, as well as the gentleman, my dear friend from Rhode Island, Mr. Cicilline, we're going to move on to the ranking member for any opening comment he'd like to make, but without objection, anything either of you or any of our other witnesses have in writing, please know that our awesome stenographers here, and they will be entered into the record without objection. And I would defer to the gentleman from Massachusetts for any opening statement. The gentleman would choose to make. Gentleman's recognized.
Well, thank you, Mr. Chairman.
Yes,
I want to welcome our two guests and thank them for being here. You know, at this moment, it's hard to think of what to say, given what's going on in our country. I mean, all the rules that we're seeking to overturn have all gone through a vigorous vetting process, the normal regulatory process. There's been comment periods, consultations with agencies. I go on and on and on and on, some for years. And we're all, my friends seem to be upset by that fact. But as we gather here today, President Trump has instituted a number of executive orders that have caused a great deal of confusion, heartache, and quite frankly, embarrassment to our country. I have I got a call from one of my colleges in Massachusetts where a doctoral student, PhD doctoral student who had been through the vetting process and was accepted into the program, has been going to the program, went home to see his family, and all of a sudden can't get back. We have dual citizens, dual nationals, people who are U.S. citizens who because of the way their home country operates, are also citizens of that home country who are being denied access back into their home country, the United States, for 90 days. And we know that there was no consultation with Congress on this policy. There's obviously no consultation with the relevant agencies designed to implement the process, because the Department of Homeland Security didn't have a clue what was going on. Department of Defense didn't have a clue what's going on. I mean, it is an embarrassment, and it is, the policy itself, I believe, is discriminatory, and I think it undercuts our national security as well as our credibility around the world. So we all behave like nothing's going on, but, you know, a bit of advice to the majority in this Congress. The President is of your party, and if I were you, I would ask him in the future to, at a minimum, consult with you before he goes forward with some of these ideas. So that's what we should be talking about. This other stuff has actually gone through a long process where everything has been commented on and people have been consulted. And so, anyway, I regret we're doing this. I would just say one final thing. We are the Rules Committee. I'm hoping that these aren't going to be closed rules, that there'll be some opportunity for people to either amend these measures or have some sort of input. And with that, I yield back my time.
Chairman yields back his time. Thank you very much. We're now going to move to the first panel, H.J.Res 40. Mr. Goodlatte, I'm delighted that you're here. Thank you for taking time to do this. The gentleman, the young chairman of the Judiciary Committee, is recognized.
Well, Mr. Chairman, thank you very much. I want to thank all the members of the Rules Committee for allowing me to testify today on H.J.Res 40, a resolution providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Social Security Administration relating to implementation of the NICS Improvement Amendments Act. This is an issue that is of great importance to many Americans across the nation. On December 19, 2016, in the waning days of the previous administration, the Social Security Administration published a rule finalizing the criteria for sending the names of certain beneficiaries to the National Instant Criminal Background Check System, otherwise known as NICS. These individuals would be prohibited from purchasing firearms and possessing explosives. Under the rule, an individual's name will be sent to the NICS database if they receive disability insurance or supplemental security income benefits based on having a mental health condition. The person is between age 18 and the full retirement age, and the SSA determines that the person needs a representative payee to manage their benefits. The proposed rule is worrisome to a number of people for a variety of reasons. First, there simply isn't any data that suggests there is a connection between the need for a representative payee to manage one's Social Security disability benefits and a propensity towards gun violence. Second, there is a complete dearth of any meaningful due process protections prior to the SSA's submittal of the names to the NICS database. Although the NICS Improvements Act of 2007 allows agencies to transmit the names of individuals who have been adjudicated to lack the capacity to manage their own affairs, SSA's process does not constitute an adjudication and does not include a finding that individuals are broadly unable to manage their own affairs. This would be the only instance where an individual's Second Amendment rights are taken away without any semblance of due process. For instance, currently, citizens lose their right to possess a firearm when they have been convicted of a felony or misdemeanor crime of domestic violence by a judge or jury, or have been dishonorably discharged after a hearing, among other reasons. All of these losses of rights have one thing in common. They all protect the due process rights of those facing the loss of their Second Amendment rights. Some may point to the rule's appeals process as providing a form of due process. However, the appeals process is severely flawed. When someone's name is sent to the NICS database, the individual may seek relief from the firearms prohibition through the SSA's appeals process. Excuse me. The SSA's appeals process requires the individual to prove that restoring their Second Amendment rights would not pose a danger to public safety or be contrary to the public interest. The individual must provide the following evidence as part of the appeal: a written statement from the individual's primary mental health provider assessing the applicant's mental status over the preceding 5 years, and written character statements from others who can attest that the individual would not pose a danger to himself or others. In every other instance where someone is facing a loss of their ability to possess a firearm, the burden is on the government to prove that the individual should have their rights taken away. Conversely, under this flawed system, the individual bears the burden against the government. This is not what due process looks like. Mental health advocates and Second Amendment advocates agree that this is a bad rule, including the Consortium of Citizens with Disabilities, the National Rifle Association, and many others. Even the National Council on Disability, an independent federal agency making recommendations to the President and Congress to enhance the quality of life for all Americans with disabilities and their families, has called on Congress to utilize the Congressional Review Act to repeal this rule. I appreciate very much the Rules Committee's time. I urge you to bring the resolution to the floor as quickly as possible, and I want to thank the chief sponsor of this measure, the gentleman from Texas, Mr. Johnson.
Mr. Chairman, thank you very much. Mr. Cicilline, welcome to the Rules Committee. We're delighted that you're here.
Thank you, Mr. Chairman.
Please know that the gentleman comes up here to advocate. We're delighted that you took time to do that. I know Ms. Waters is here, although I have a difficult time knowing she's got a new head of hair back there. She got a new haircut, but we're delighted that
Looking
you're
more
here.
beautiful than ever.
I couldn't have said it any better myself. Gentleman's recognized.
Thank you, Mr. Chairman and distinguished members of the Rules Committee. I appear this evening in opposition to House Joint Resolution 40, which would disapprove a rule adopted by the Social Security Administration implementing the NICS Improvement Amendments Act of 2007 to address the very real impact of gun violence. Mr. Chairman, this joint resolution is a sweeping and dangerous procedural maneuver that may have devastating effects on the safety of the American people. Unlike the ordinary course to revise rules for the administrative process, legislation, or congressional oversight, a resolution of disapproval under the Congressional Review Act has extraordinary ramifications. First, the resolution applies to the entirety of a rule, not a single aspect of it. As the nonpartisan Congressional Research Service has observed, the Congressional Review Act is wholly unlike the normal legislative process because, and I quote, "it cannot be used to modify or restructure a rule in order to make it acceptable to Congress," end quote. This zero-sum approach to rulemaking would result in the nullification of both controversial and non-controversial aspects of any rule that is vacated through this procedure, including agency action that is expressly required by Congress under federal law. Secondly, there is little evidence in support of my Republican colleagues' bald assertion that this is a so-called midnight rule. Prior to adopting any rule, federal agencies must follow the robust and time-consuming requirements of a host of federal laws designed to ensure a transparent and accountable rulemaking system. These laws include the Administrative Procedures Act, the Regulatory Flexibility Act, the Unfunded Mandates Reform Act, the Paperwork Reduction Act, and the Congressional Review Act. In this instance, the Social Security Administration provided a 62-day period for public comment that ended on July 5th, 2016. There is no evidence that the agency did not provide adequate time for public input, as more than 91,243 timely submitted comments were filed by advocacy groups and individuals. Moreover, the agency adopted the rule in response to a mandate by Congress to implement a statute, the NICS Improvement Amendments Act of 2007, which expressly requires federal agencies to provide relevant records to the Attorney General for inclusion in the National Instant Criminal Background Check System, or NICS. Finally, and perhaps most importantly, rules disapproved through the Congressional Review Act may never be adopted in a substantially similar form unless Congress specifically authorizes it through the enactment of a statute. This pernicious aspect of the Congressional Review Act demands that it be used with the utmost care. Unfortunately, that is not the case for consideration of this joint resolution. This measure would vacate a rule specifically adopted to protect the public from persons who are likely to act in a manner dangerous to public safety. There have been no hearings on this matter in the 115th Congress or the 114th Congress. We have not heard from experts on the substance of the rule. Critically, none of the more than 50 new members of Congress have had an opportunity to consider the ramifications of this resolution, which bypassed consideration by the Committee of Jurisdiction, namely the House Judiciary Committee. In sum, this bald political maneuver is entirely divorced from the substance of the Social Security Administration's rule, which is designed to protect Americans from the scourge of gun violence. It's nothing short of a handout to the gun lobby that belies the Speaker's promise of regular order and substance over politics. Mr. Chairman, our constituents demand that we take actions to reduce gun violence nationally. Last Congress, House Democrats gave voice to millions of these Americans by sitting down on the House floor so that we could stand up loudly and clearly decry gun violence. House Joint Resolution 40 is a shameful reminder that rather than address the important issues that affect American families, My colleagues are attempting to provide yet another handout to special interests. In closing, I urge my colleagues to oppose this resolution, and I yield back.
Mr. Cicilline, thank you very much. Mr. Chairman, thank you for being here today. The issue of guns and gun violence is probably not going to go away. Responsible laws that should be in effect, and laws that make sense, however, I believe in. I have been approached by a number of people, several from Dallas, Texas, and Garland, Texas, who expressed to me that they were concerned that they would fall under this rule, and I don't know that they did or did not, but my belief is they probably did. I've known them for years. They did not believe that this was the kind of thing that they were impaired because of their disability, about why they were receiving SSI. And it's these kinds of things that I think government goes too far on. Was there any discretion that was given in the rule that they did? Or do you just have to go, I think you outlined it, did you just have to go prove it yourself?
No, I think the due process concerns here are manifest. I share your concern that if there's a finding that someone has committed a crime that is either a felony or a misdemeanor involving domestic violence, or have been found to be a danger to themselves or to others through a mental health commitment process before a court, that record should definitely go into the NICS system. We have a problem getting some of the states to get all that data into the system, but there are many reasons why people have someone appointed to help them with their Social Security benefits that in no way touch upon whether or not that person is a danger to themselves or others and therefore could not be trusted with a firearm. And so, to me, this is exactly the kind of thing that the Congressional Review Act is intended for. It's to go in, and where bureaucracies take the law into their own hands and deny citizens their due process rights, we should fix that, and that's what we do with this.
Well, I'm delighted
CRA.
that you're here. I have pled with these people to understand that I felt like that their rights should not have been taken from them, and this is a chance to right that wrong, so I appreciate it very much. Dr. Burgess?
Thank you, Mr. Chairman. Chairman Goodlatte, if I could, I realize I'm going to ask some questions that are really pretty basic, but the reason that this rule was promulgated was because?
Well, in my opinion, the rule was promulgated to promote limitations on the access of American citizens to their Second Amendment rights to own firearms. And somebody felt that this was a good indicator of somebody who shouldn't have it, but it deprives that individual of their due process rights, makes that determination without their having those rights afforded to them.
If I understand correctly, the predicate legislation was passed in 2007, calendar year 2007, and the rule now is coming to us. So that seems like a significant delay. Was there a problem that occurred that required this activity by the agency?
I could not tell you the answer to that question because I'm not aware of the reason why the Social Security Administration would determine that they should deny Social Security and SSI recipients the opportunity to have their Second Amendment rights simply based upon something that is not tied to whether or not there is a finding that they're a danger to themselves or to others.
So in this type of rulemaking, I think if I understood you correctly, the burden of proof that it's not necessary is on the Social Security recipient. Is that correct?
That's correct.
Is that unusual to put the burden of proof on the citizen?
It's very unusual, and it is, with regard to protecting the rights of American citizens, I think it is offensive, and that's why this should be overturned.
Well, I thank you for being here with us this afternoon, Mr. Chairman. Thank you for the consideration. I'll yield back my time. Thank you.
Thank you very much, gentleman of Massachusetts.
Gentleman from Rhode Island want to say something?
I just wanted to point out with respect to the determination, the rule requires a finding of two things. One is that the individual have a very severe long-term mental disorder. That is described, there is a list of mental disorders at 20 CFR 404. These are persistent, serious, and chronic conditions of mental disability. In addition to that, the individual has to also be not capable of managing their own affairs. That's a capability determination. So the conclusion, I mean, the purpose of the rule is if there are individuals who are suffering from a severe long-term mental disorder, as described in 20 CFR 404, and they're incapable of the daily functioning of their managing their affairs, that those two things taken together present a reasonable conclusion that it is a danger for that person to go in and purchase a gun. It also provides notice to the individual that they are disqualified, and then an opportunity to challenge that before it goes into the NICS system. So there is a burden, but this person has already been determined by the agency as a result of a medical exam and other criteria to suffer from a very severe long-term mental disorder. I think that's the purpose of the rule, and your resolution of disapproval will prevent Congress from ever addressing this issue.
Mr. Chairman, if I might be allowed a redirect.
I'll yield to the gentleman so I have the time.
So, Chairman Goodlatte, is that consistent with your understanding that there has to be the establishment of a significant disability, or is it someone who merely asks for help in dealing with financial affairs may be caught up by this rule?
Well, that requirement is there, but the fact that one has a mental health disorder in and of itself is not equal to the propensity to commit gun violence. And therefore, the denial of the due process rights and giving this after-the-fact relief that Mr. Cicilline accurately describes does not in any way satisfy, I think, most people's perspective of what is fair due process rights. The individual, if there's a concern that they are going to acquire a gun or have a gun and would use it in a violent way, can be brought before a mental health commitment hearing before a judge who would make a determination the individual is a danger to himself or to others, and that would be the basis for putting the information into the NICS system. Without that, the inability to balance a checkbook, which is part of the criteria he just described, should not disqualify someone from their Second Amendment rights.
Thank you, Chairman, for his clarification. I thank the gentleman from Massachusetts for yielding additional
Look,
time.
I don't want to belabor this point because this is, this process is what it is here. The gentleman from Virginia, I think, used the word offensive when he described what this rule did. You know, what I think is offensive is the fact that we have massacres on a regular basis in this country, and the best that we can expect from the people who run this House is a moment of silence on the House floor. At some point, we'll get serious about having a discussion about gun violence and what we might do. We can't even get a bill for background checks brought to the floor, and I find that offensive. With that, I yield back.
Thank you very much. I'd like to ask a question. Do either one of you recognize the bill that Mr. Murphy put forward before this Congress? Tim Murphy?
I'm familiar with the bill, yes.
It was actually concerning mental instability and the ability that we have to be able to identify and stop these things, which is where evidence was driving. Evidence was driving to the need to make sure that communities and people and families recognize this. So to say we've done nothing when in fact the evidence supported Mr. Murphy's bill, I think is a better representation. We have done things.
And Mr. Chairman, if you would yield on
I
that
would.
point,
I'm asking a question
The House,
about
in a very bipartisan way, passed the 21st Century Cures Act, into which was also folded.
that was Mr. Murphy, and he was
Mr.
included in
Murphy's,
there.
mental health bill. I think that was a very good constructive thing to do to help address this problem.
I thank you. That was what I was looking for. The evidence that we saw from psychologists, medical doctors, and others suggested this was, I mean, the thing that would be a proactive attempt by Congress to speak with a voice loudly on a bipartisan, overwhelming vote. And
Mr. Chairman,
that-
I do think that, part of our response has to be, of course, to ensure that funding is available for the treatment and identification of serious mental illness. That's no question about it. This rule, however, has a different purpose. And with all due respect to the chairman, it doesn't simply require that if you can't manage your checkbook. There are two findings, that there will be a severe long-term mental disorder and incapacity. So, this is an approach to say, not only should we treat people who have serious mental illness, but let's try to keep guns out of the hands of people who have a very severe long-term mental disorder, coupled with an inability to just function daily in the daily operations and like that. Those are two good indicators that it's probably too dangerous for that person to have a gun.
perhaps that's true. I think my point was the word done nothing, or this Congress has done nothing, is doing nothing. When I think that the evidence that was presented before this committee was overwhelming, that suggested that healthcare professionals, doctors, psychologists, people in the industry who see the effect of gun violence said this was the best that could be done, that Congress should speak with, and that's all I'm trying to suggest. Yes, sir.
I just want to make clear once again, I responded to both points, both halves of the finding requirement that Mr. Sisling cites when I said that the mental disorder does not equate to propensity to commit gun violence. That's part one of his argument. Part two is the inability to balance checkbook should not disqualify someone from their First Amendment rights, Second Amendment rights.
Yes, sir. Yes, sir. Thank you very much. The gentleman from Georgia? Gentleman from Georgia does not seek time. The gentleman from Florida does not seek time. Judge, good to see you. The gentleman from Alabama, Mr. Byrne, you're recognized.
Thank you, Mr. Chairman.
Yes, sir.
This is a pretty personal issue to me. My grandfather was shot and killed by a mentally ill person, so I understand the personal consequences of this. Mr. Chairman, I remember as a baby lawyer that I had to be on the list of appointments for commitment proceedings. I'm sure you had to do that in your career as well. And my memory is, in order to commit somebody against their will, you have to find both that they have a mental illness and that they pose a substantial threat to themselves or someone else, as evidenced by a recent overt act. So it's a pretty significant finding, and you go through a due process hearing. State of Alabama, it's done at probate court levels. The probate judge handles the judicial proceeding. There was a separate proceeding, as I recall, where you appointed someone, a custodian, to manage their financial affairs because they had some mental incapacity to be able to balance their checkbook, pay their bills, et cetera, so that you could have a custodian without having to meet the threshold of being mentally ill to the point of requiring commitment. So is that sort of the distinction we're drawing here? You're someone who's got I think the word is mental disorder, but not someone who's got a mental disorder to the extent that they pose a threat to themselves or somebody else. Is that the distinction?
Well, that's right. There is a requirement in this regulation that you have a finding that they have a severe mental, long-term, I think it's part of the language, mental disorder. But there is no requirement that finding in any way associate with the propensity of the individual to be a danger to themselves or to others. And there's no advanced due process rights, as there is in the type of proceeding that you participated in and that I participated in as well as a young lawyer. So I think that is a major defect. The other major defect is that I don't think the Social Security Administration is the agency that should be put in the position of making that determination. They're not a court of law. So for those reasons, I think this is deeply flawed and violative of people's due process rights and should be stricken.
And as I remember, Mr. Chairman, the reason we went through the proceeding that I talked about for commitments was because we had some federal court cases from the early, mid-'70s that said you can't deprive people of their basic rights under the Constitution by merely saying they're mentally ill. You've got to make that second finding that they pose a threat to themselves or somebody else, as evidenced by a recent overt act. So we've already have some court...
That's to deprive them of their liberty and require that they undertake
So essentially, we have this
court-ordered treatment. But I would say the principle of protecting your
Second
rights,
Amendment
Bill of
rights.
would rise to that level.
So we could see a federal court case that would challenge this regulation because it violates people's Second Amendment rights, not just their Fifth Amendment and 14th Amendment rights. So it seems to me, and I don't know, it hadn't been adjudicated, but it seems to me by reversing this, we're actually sparing us from having to go through that litigation because somebody's going to challenge that, I would think. And I would prefer, remember, I'm talking to you as a victim's family. I would prefer for us to have the full due process rights for anybody who's going to lose one of the most sacred rights we have under the Constitution.
And we are sworn to uphold that same Constitution that the judges are, so we can make that judgment ourselves, and I think that's exactly what this CRA does.
I concur with you, and I appreciate your bringing this forward. Now, yield back, Mr.
The gentleman yields back his time. Thank you very much. The gentleman from the state of Washington, Mr. Newhouse.
Well, thank you, Mr. Chairman.
Yes, sir.
And thanks to both Mr. Goodlatte and Mr. Cicilline for bringing this issue forward. And all of my burning questions have been asked already and answered adequately, and I just wanted to say that it's, certainly no one in this room wants to see continued gun violence in this country, and Mr. Cicilline, being a former mayor of a large American city, certainly dealt with this issue on a professional basis in your former life. But in my opinion, taking away an individual's constitutional rights in order to solve a problem that isn't the right way to go. And if I understand what both of you are saying, the Social Security Administration puts themselves through this rule and in the position of being the judge, which goes against the long-standing process that we have in this country to protect citizens' constitutional rights, for whether it's the Second Amendment or many other things. And so, unless I'm seeing it differently, that would be, for me, enough cause for pause, and that we should overturn this rule just on that basis. But thanks to my good colleagues who, on both sides, who asked good questions. Mine have been answered, and I appreciate you both being here and helping us understand this issue.
Gentleman yields back his time. The gentleman from Colorado, Mr. Buck.
Thank you, Mr. Chairman. Mr. Cicilline, would you advocate taking away someone's right to vote if they fit those same criteria or any other constitutional right?
Again, I think what this rule provides is that before someone's information is put into the NICS system, they are notified of the intention to deliver those records. And remember, this grew out of states and localities not sharing information with the NICS system. This was a very persistent problem. So the rule as currently written provides notice to the individual who then can challenge that filing of those documents.
But you're
with NICS.
picking one.
So I reject the notion that there's not due process.
I wasn't asking about due process. I was asking about constitutional rights. You're choosing one particular constitutional right.
You're right, and we do that all the time. We have prohibitions, for example, that preclude people who have been adjudicated mentally ill from having a gun. And we do that because we've made the determination that that is so dangerous that you ought not have a gun. So there are trade-offs. We prohibit people who are convicted of a crime from possessing a firearm.
Well, no,
Possess a machine.
a felony, not a crime.
So it is not an absolute right. We have the right to regulate the use of a firearm and who can have them based on the dangerousness to the community. Those are well accepted. So it's not an absolute right. And all this rule does is say, if you are severely mentally ill and have a long-term mental disorder and you are incapable of managing your fears, they notify you, we're going to provide this information to the NICS system. You then have a right to challenge it.
You have a right to go hire a lawyer. You have a right to spend your money. You have a right to defend yourself because some bureaucrat in Washington, D.C. believes that this particular type of constitutional right should be taken away from you, while the right to vote, the right to remain silent, the right to an attorney are not going to be infringed at all. You're choosing a particular constitutional right to go after.
But my constituents and your constituents also have a constitutional right to life, liberty, and the pursuit of happiness, and to be free from gun violence. So my constituents have a right to sit on their porch on a summer day and watch their grandchildren play and know that they can do that free from being killed by a gun.
And my constituents have the right to defend themselves against people, even if they...
And I think this rule strikes the right balance. But the notion that somehow it's an absolute right, incapable of being regulated, is just not true.
And I haven't suggested that for a minute, but tell me, which of the massacres that Mr. McGovern talks about would be alleviated by this particular rule? Which person
Well,
that...
there have been virtually every mass shooting in the last, well, not virtually, many of the mass shootings have involved someone with a serious mental illness.
that was under the jurisdiction of the Social Security Administration and would have been given due process rights with those particular findings?
This rule.
No, but I
grows out
asked
of
you
the-
which.
I don't know the number, but this
Okay.
rule grows out of the recognition that there is a real problem in this country of people who have a serious mental illness, who have easy access to firearms. This doesn't solve all the problems, but it provides some relief, some effort to make sure guns stay out of the hands of people who shouldn't have them. We should support that.
And
the rulemaking process is a way you can modify that, improve it, but if you act today in this disapproval resolution, we can never touch this area again, and that does a gross disservice to the American people.
How many people have defended themselves against intruders, have defended themselves with their right to bear arms
None
to
of those
protect
people,
themselves?
if they're not mentally ill and incapable of managing their affairs and suffering from a long-term mental disorder, they won't be implicated by this rule.
Will the gentleman yield for 1 second?
Sure.
Yeah, I guess I would just say, the gentleman has lots of questions, we have lots of questions too, but the way this process works is that this thing is just going to be brought to the floor, and without hearings and kind of the normal regular order, you're just going to ask people to vote yes or no on it. The gentleman has so many hearings, so many questions, we ought to have a hearing on this outside of the Rules Committee, and actually talk about this, rather than bringing it to the floor under this kind of expedited process that I think violates regular order. So I thank the gentleman for yielding, but I mean, why don't the committees of jurisdiction talk about this before it comes to the Rules Committee?
There are so many bad rules that have been shoved down our throats by the Obama administration in the last few months of the administration that we don't have the opportunity to hold hearings on every single bad rule that came down.
Well,
and that's what we're trying to deal with
Yeah,
here,
and
is an
I-
administration that lost
Right.
power because the American people lost confidence, and we are trying to deal with some of the bad rules that came
And
down.
I have an article here I'd like to ask unanimous consent to insert in the record. It says, Trump signs executive order requiring that for every one new regulation, 2 must be revoked. No talk about the substance. Another nice press release, another nice soundbite. We ought to do our job. And if that means that we have to spend a little extra time doing hearings, we ought to do it.
And you know what? The president ran on that very proposal, and the American people elected him, and that's what the president is implementing right now. I yield back, Mr. Chairman.
Gentleman yields back his time. The gentlewoman, Mrs. Cheney.
Thank you, Mr. Chairman.
Yes, ma'am.
I agree with my colleague, Mr. McGovern, that we ought to do our job. And I think that one of the most important jobs we have in this Congress is to begin to relieve the undue burden of regulation we've seen from this administration over the last 8 years. And I wanted to raise something in particular. The gentleman from Rhode Island mentioned that there had been over 60 days of comment allowed on this rule. And I can certainly tell you that my constituents in Wyoming have faced an unbelievable onslaught of rules imposed, public comment sought, and then absolutely no input taken at all. And so I guess my question would be to the gentleman from Rhode Island, do you believe that a 60-day comment period can somehow substitute for the due process rights someone is due before you take away their constitutional right to keep and bear arms?
Well, again, I would say to the gentlelady, in answer to your question, there were 91,243 timely comments. So I think there was, in fact, deep engagement with the American people and advocacy groups. I would also say that, once again, just to repeat myself, that no one loses their constitutional rights under this rule. They have an opportunity, again, to receive, they're notified of an intention to file these documents as Congress directed by passing the Accountability Act, and then they have an opportunity to challenge that. And so I don't think anyone loses, no one loses their right to possess a firearm without process.
So is it your view then that your due process rights, any of your constitutional rights, frankly, depend upon you bearing the burden of proof to demonstrate that you have those rights, which is what this does?
Yeah. Again, this is a notice to an individual that says, we will file these documents with the NICS system as Congress has directed us to do a better job of, and then gives them an opportunity to say, despite that finding of a severe mental disorder and my inability to function in daily tasks, I still ought to be able to buy a gun, that yes, I think it's appropriate for that person to have a burden to make that case.
And that the Social Security Administration should be able to adjudicate whether or not somebody can exercise their constitutional right to keep and bear arms.
That is not what they do. We've directed the NICS system to collect that information. All the Social Security Administration makes a determination, which they're qualified to do, to qualify for benefits, that you have a very severe, long-term mental disorder and that you are incapable of managing your daily affairs. They already make those determinations.
Do we know of those 91,000 comments, any of them that were actually taken? Or is that just the number of comments that were offered up? That could very well be an indication of the dire concern about this regulation as it was passed.
I don't know what of those comments were adopted in the rule. I know that those many comments were in fact made.
All right, thank you. I would just like to end by saying that I think it's very important that we recognize we should not put any senior citizens in this country in the position of having to choose between getting the benefits that we have promised them and exercising their constitutional rights. So I want to thank Chairman Goodlatte for bringing this forward, and I fully support repealing this not just burdensome regulation, but regulation that fundamentally violates constitutional rights.
Gentleman yields back time. Thank you very much. Is there any other member that's seek to question our panel? Seeing none, I want to thank both of you. Please do remember our awesome stenographer needs anything you brought in writing, and you could leave that for her. Thank you very much, Mr. Cicilline. Thank you very much. Is there anyone else who would seek to give testimony on H.J.Res 40?
Thank you, Mr. Chairman.
Seeing none, this would now stop that, end that process. We'll now move to the second panel, asking the gentleman from Dallas, Texas, the chairman of the Financial Services Committee, the ranking member, Ms. Waters, from Los Angeles, California, H.J.Res 41, if they would please come and take their position in the at the table. I want to thank both of you for being here. Mr. Chairman, we're delighted that you're here without objection. Anything you brought in writing, as well as the gentlewoman, would be entered the record, and the gentleman is now, as soon as he turns on that, there it is. That's great. The gentleman's recognized.
Thank you, Mr. Chairman, Chairman Sessions, and members of the Rules Committee. Thank you for the opportunity to testify in support of House Joint Resolution 41, which was introduced by gentleman from Michigan, Mr. Huizinga, the chairman of the Subcommittee on Capital Markets, Securities, and Investment of the Financial Services Committee. This resolution disapproves a controversial Securities and Exchange Commission rule that puts American energy companies at a competitive disadvantage. The SEC's flawed rule does this by placing on American public companies an unreasonable compliance burden that is not applied to many of their foreign competitors, especially state-owned companies. Mr. Chairman, virtually every day we hear from our constituents about how this economy is still not working for many working Americans. One of those working Americans I hear from, Keith from Dallas, wrote to me about the struggles he is going through. Quote, "I am 53, I have a grown son who lives with me. It seems like the cost of everything keeps going up, yet wages do not keep pace," he said. Another constituent of mine, Chris, told me of the struggles he has trying to keep his small business up and running. Quote, "We have seen wave after wave of federal regulations affect our ability to grow," he said. Quote, "The cost associated with additional reporting, regulations, auditing, and compliance are massive. The money spent is significant and costs jobs and potential jobs," unquote, he added. So, Mr. Chairman, Keith and Chris and millions of other Americans just like them surely aren't helped by the report released just last Friday that shows our economy grew at a lackluster 1.6% last year, its weakest pace in 5 years, and the American people remain stuck in the slowest economic recovery in the post-war era. Their economic opportunities simply are not helped by a top-down political regulation that gives many foreign companies an advantage over American public companies. But that's exactly what this SEC rule we're talking about does today. This SEC rule implements Section 1504 of the Dodd-Frank Act, and since this rule applies only to public companies, state-owned companies, their competitors, do not have to comply. This rule forces American public companies to disclose proprietary information that can be obtained by their foreign competition, including state-owned companies in both China and Russia. While giving many foreign corporations an unfair advantage, this SEC rule has nothing to do with investor protection or consumer protection or anything else we were told Dodd-Frank was supposed to do. As the acting chairman of the Securities and Exchange Commission has said, this group, quote, neither reforms Wall Street nor provides consumer protection, and it is wholly unrelated and largely contrary to the SEC's core mission, unquote. In addition, the SEC estimates that ongoing compliance costs for this rule could reach as high as $591 million per year. That's $591 million that American public companies could be using for better, more productive uses like creating more jobs and investing in their workers. The SEC itself admitted these compliance costs would force American public companies to, quote, potentially divert capital away from other productive opportunities, unquote. That's a loss of jobs, Mr. Chairman. And speaking of diversions, Mr. Chairman, you and others on the committee may be told that this SEC rule is an anti-corruption tool. But let me remind you, Mr. Chairman, and all members of the committee, that the Foreign Corrupt Practices Act, which the SEC and the Department of Justice administer, makes it unlawful to pay foreign government officials when it comes to winning or maintaining business opportunities. And in fact, just this month, the SEC brought forth enforcement actions or settled 4 separate cases for violations of this anti-corruption law. It remains on the books. So even without this SEC rule, fraud will still be fraud, and corruption will still be corruption, and both will still be illegal. And the SEC and the Department of Justice will still have the authority to vigorously pursue those who break the law and hold them accountable, as they well should. Let's also remember that the joint resolution before the committee today does not and would not repeal Section 1504 of Dodd-Frank, no matter how ill-advised it may have been. Rather, the joint resolution simply vacates a flawed SEC rule that mimics a previous rule that was already struck down by a U.S. district court. The SEC's revised rule still appears to fly in the face of the statutory language of Dodd-Frank, which requires that the SEC, quote, to the extent practicable, make available online to the public a compilation of the information, unquote, required to be submitted. The SEC's rule, approved in June of last year, goes far beyond the statute and mandates public, specialized disclosures in a way that is much more costly and more complicated than other alternatives which the plain language of the statute requires. Such indifference by the SEC should concern both my colleagues who unequivocally support the text of Dodd-Frank, as well as those like myself who demand that regulators not exceed the authority granted them by Congress. As such, this House should wholeheartedly reject this flawed rule and pass the joint resolution offered by Mr. Huizinga, which simply tells the SEC to go back to the drawing board, comply with the statute, and come up with a better rule that does not undercut America's ability to compete and invest in its workforce. Mr. Chairman and members of the committee, passing laws that promote a healthy economy with more jobs, higher wages, and economic opportunities for all certainly must be among our top priorities. That's the best thing we can do to help people like Keith and Chris and the millions of others who feel they're working harder but just can't seem to get ahead. To achieve this goal, Congress and the administration must work together to find flawed, duplicative, and top-down regulations that simply don't work and close our economy to innovation, growth, and opportunity. That's how we protect American workers. This joint resolution is just a start, and I look forward to coming before this committee many more times during the 115th Congress to discuss with you solutions that will help build that healthy economy we all want for our fellow citizens. Thank you, Mr. Chairman.
Mr. Chairman, thank you very much. The gentlewoman from Los Angeles is recognized.
Thank you very much, Mr. Chairman. Thank you, Mrs. Slaughter, and members of the committee for allowing me to share my views on H.J.Res 41. Before I begin, I'd like to point out that 14 members of the Financial Services Committee as well as the millions of Americans they represent, are being denied the opportunity to discuss this issue through the regular committee process. So far, this Congress, the Republican leadership, has completely ignored regular order, conducted business behind closed doors, and limited debate. The resolution before us is no exception. Indeed, the Republicans could have introduced a bill to repeal the rule that they're seeking to invalidate, but that would mean they would have to first hold hearings, mark up the bill, and provide an opportunity for amendment. Such a bill would also be subject to additional hurdles in the Senate, including overcoming the 60-vote requirement to end a filibuster. This resolution would strike a crucial and anti-corruption provision of U.S. law, Section 1504 of Dodd-Frank, which has a long legislative history and reflects our country's desire for transparency and accountability when it comes to the extraction of natural resources from foreign countries. Section 1504 of Dodd-Frank requires companies listed on the U.S. exchanges to disclose payments they make to governments for oil, gas, and mining resources. The kind of transparency provided for in Section 1504 allows shareholders to make better informed assessments of opportunity cost, threats to corporate reputation, and the long-term prospects of the companies in which they invest. Opening the extractive industries to greater public scrutiny is also key to increasing civil society participation in resource-rich countries, which are often developing countries that are politically unstable, many rife with corruption, with a history of civil conflict fueled in part by natural resources. Public disclosure of extractive industry payments can help diminish the political instability caused by opaque governance, which is not only a threat to investment, but also to our own national security. That's the truth about Section 1504, but like any provision that is designed to shed a light on corruption and to bring shady dealings into the harsh light of day, it seems there are those who are opposed to it. But the world is with us on this. After the SEC issued its initial rule in 2012, the rest of the world followed our lead, establishing a global standard for the public disclosure of extractive payments companies make to governments, which has provided a level playing field. The U.S. law and its implementing rules cover all companies listed on the U.S. stock exchanges. Other countries followed U.S. leadership. Let me just say this. Other countries followed U.S. leadership, and now 30 countries have adopted similar disclosure rules that cover the vast majority of oil, gas, and mining companies that compete with American firms. This includes all EU member states and the UK. Leading global oil companies are already reporting, including BP, Shell, and Total, as well as Russia's state-owned companies, Gazprom, Rosneft, and Lukoil. They are now entering their second year of reporting under EU rules without any negative impact. Moreover, the SEC final rule accommodated industry concerns and includes a generous phase-in period. U.S.-listed companies are not required to report until 2019. The final rule also provides for case-by-case exemptions if covered companies face any implementation issues. Therefore, the rule does not put U.S. companies at a competitive disadvantage, nor does it impose an unreasonable compliance burden. But we know what this resolution is all about and who it is designed to help. In his inaugural address, President Trump said that, and I quote, "We are transferring power from Washington, D.C., and giving it back to you, the people." The only so-called people helped by this resolution are multinational oil companies headquartered in the United States and kleptocracies around the globe, which are ruled by thieves and would be able to continue to exploit natural resources and steal from their citizens. And let's be clear, this resolution is a gift to President Trump, who has embraced corrupt strongman leaders around the globe in countries such as Russia and Egypt. It is also a gift to big oil, and in particular to ExxonMobil, which under the leadership of Rex Tillerson, Trump's nominee for the Secretary of State, had a dire record on transparency. For example, one ongoing anti-corruption probe involving ExxonMobil in Nigeria highlights the need for strong transparency rules. Authorities in Nigeria are now investigating how Exxon reportedly paid $600 million to renew 3 oil licenses that may have been valued by the Nigerian government at $2.55 billion. Improved payment transparency would shed light on and deter these types of questionable deals. Under Mr. Tillerson's leadership, ExxonMobil has mastered the art of paying lip service to transparency while doing it all it can to undermine these efforts behind the scenes. In its public statements on this provision, ExxonMobil has touted its support for the Extractive Industries Transparency Initiative, which is a voluntary system of reporting principles for the extractive sector, which, while still refusing to publish its full payment history. Just like President Trump, Exxon is not just sidestepping the rules, it is actively trying to bring them down. Mr. Tillerson served as chairman of the American Petroleum Institute, a powerful oil lobby group that has fought against Section 1504 every step of the way. And this is alarming. It is alarming that congressional leadership would consider undermining American efforts to combat global corruption by rolling back this anti-corruption measure, which protects American companies and democratic interests around the globe. It is especially surprising that this Congress would prioritize such a move in the first days of a new administration. I yield back the balance of my time.
Thank you very much. Mr. Chairman, I want to thank you for taking time to bring this effort to us. The rules and regulations have a direct impact on the cost of business, which directly impacts the ability that they have to make money, which impacts directly the ability that they have to hire their employees and directly impacts the amount of take-home pay that an employee gets. You were in reference to take-home pay. Take-home pay is wages that are paid. And in my opinion, during the last 8 years, we've seen that flat. I tell people back in Dallas, Texas, thank goodness for what we did December 18th, a full year ago. Gave more take-home pay because we did away with the oil export ban, which gave people more take-home pay, not higher wages, more take-home pay because they spent less at the pump. I want to thank you for bringing this legislation that would help, especially whatever these companies might be. If it's an energy company, it might be, but others who will do away with expensive regulatory cost to hire more people or to give more take-home pay. I appreciate that a lot. We need that in the district that I represent, which is directly next to yours, and I think I know the needs of that district too. I've been around it for a little bit, and I'm really proud of what you're doing today, and thank you very much. Chairman Cole?
Thank you, Mr. Chairman. I regret having missed most of my friend's presentation. I was detained on an appropriations issue, but and I don't have any questions other than I just want to join the chairman and laud you for doing this. I mean, this whole effort to roll back regulations, which is obviously a major thrust of the new administration, has been a continuing concern of this Congress, certainly the majority in this Congress, as my friend knows. He's been a leader in that regard. I know will continue to be. So thanks for bringing it here, and I hope we see you a lot more with a lot more legislation, and I suspect we will.
And
I look forward to the opportunity.
And we want you to be up here too, please.
Mr. Chairman, I assure you I will be here, despite the fact that I don't expect to win anything in this Rules Committee.
Well, look-
Mr. Chairman, if I may, you asked me to.
Yes,
You allowed
ma'am.
me to speak. I just want to share with you that I am going to pay a lot of attention to conflict of interest. I'm going to persist that we have some discussion about any attempts to do away with regulations that would hide the fact that there are a conflict of interest. So I appreciate your welcoming me here. You always have, but I assure you that I will be here.
Well, this was, my comment back was, I know that you have perhaps some other feelings or other ideas, and you're always welcome
Thank
up
you.
here, and you will always be made to feel welcome as long as I'm here, because, in fact, everyone on this committee appreciates you taking your time, just as the gentleman, Mr. Henslin, is doing. Thank you very much.
Thank you.
Judge, gentleman does not seek time. Thank you very much. Is there any other member that seeks time? The gentleman from Alabama, Mr. Byrne.
Mr. Chairman, I just wonder, assuming that this passes the House and the Senate, and it's signed by the President, I just wonder how many average people in America are going to wake up the next morning and miss the SEC rule on the disclosure of payments by resource extraction issuers. My prediction is none. The average person will not miss this regulation. And that's the problem with the regulations we've got in the last 8 years. They really weren't aimed at helping the average people in this country. And so what President Trump is doing, what this Congress is doing, is trying to do things that help the average people in America. And this regulation doesn't do one thing to help the average person in America. And I yield back.
Thank you very much. Gentleman yields back his time. Is there any other member that seeks time? Seeing none, I want to thank both of you for being here today. If you'll please make sure you leave anything you brought in writing for Austin stenographer to allow her an opportunity to get her work done before the sun goes down too much. And thank you very much. Thank you. Is there any other member that would seek to give testimony to H.J.Res 41? Any other member that would seek to give testimony? Seeing none, we will now move the committee forward to H.J.Res 38. I note that a former member of this committee, distinguished gentleman from Utah, our dear friend, Mr. Bishop, the chairman of the Natural Resources Committee, is here and would ask him to please come forth. Mr. Chairman, just so you know, anything you have in writing will be under the record. We're delighted that you're here. We got some new colleagues over to your right. The gentleman from Colorado, Mr. Buck, is one of our new members, and the gentlewoman, Ms. Cheney, from Wyoming. And so they are very excited about not only, as they told me, being from the West, but interested in many of the things which you'll be bringing to the committee this year. We're delighted that Chair Gentleman's recognized.
Thank you. Y'all didn't obviously ask my recommendation before you accepted this post, did you?
Rob, how much time did you spend up here? 8 years?
It seemed like 8 years every night.
Well, some nights they were 8 years.
They were. Yeah, eternity I'll never get back. And you've also got two of my former members that you took away too, so traitors, so we'll see. Thank you. All right, we're here on H.J.Res 38. It's the joint resolution for disapproving the rules submitted to the Department of Interior known as the Stream Protection Rule. There's about 5 reasons why I think you would want to make sure that this passes on and goes to the floor, hopefully without any amendments. First one is simply the rule is promulgated behind closed doors. It is based on a very opaque internal study that was never made public. We frequently ask for the data on what based this rule. It was never given. In fact, in 2015, in the Omnibus Appropriations Act, Congress demanded that they see the study, and once again, the agency simply refused to comply with congressional wishes at that time.
Number two, this act violates all sorts of laws. It violates the NEPA, violates the Endangered Species Act compliance. It violates, in my mind, the Clean Water Act when it redefines hydraulic without doing it. It certainly violates memo of understanding that the federal government had with at least 11 states. 10 were supposed to be cooperative states, one was a commenter state. They were simply shut out of the process, which may be one of the reasons why they are actually suing this entire process going forward. Three, it puts us in potential liability, as there could be actually takings litigation based on the implementation of this particular rule if we were to go forward with it. Four, this thing we have talked about many times before. Congress has passed 4 different bills over the last 3 Congresses asking this rule to be changed, not done, amended. We have had 13 hearings in our committee alone on this particular bill. If indeed this rule were to be rescinded, moved back, there is still a rule that did go through the legal processes during the Bush administration which will protect these streams. There is no danger of environmental degradation. This is simply a rule that expanded on their authority and expanded on what they were attempting to do and did so in the shadows of darkness. It seems as if the planets simply have aligned themselves as the time that after 4 attempts by this Congress and repeated efforts on behalf, the planets have aligned to actually make this a possibility right now. It's a bad rule. It's a rule that is excessive, and it is appropriate that we should try to reverse that using the CRA. Unless there is something specific you have, I'll yield back.
Thank you very much, Mr. Chairman. A few months ago, I'm not an expert on this, but the federal government was engaged in, if this is stream as in water, they were engaged in some activities. Would this have applied to them and their use of how they manage land and resources of the United States?
You're talking about the Gold King mine disaster.
Yes, sir, I am.
This probably would not have had, no, this would not have applied to that situation.
Would
but
not
it
have.
It certainly illustrated why this particular agency has not got a stellar track record on this, and certainly a 1,600 page rule that affects 400 different definitions and regulations is not going to help those situations.
Yeah, thank you very much. By the way, Mr. Chairman, I want to thank, through you, your staff who helped me as we were preparing for the new rules package, and your chief of staff was most instrumental in not only answering questions, but was very timely in her response to not only myself, but the Rules Committee staff, the gentleman, Mr. Cody, as we were preparing things. And I had not had a chance to say this to you except on the floor, but I'll say it. Thank you very much. Good work, and thank you very much for attention to the detail.
That is kind of you, and I appreciate you saying that, and I'm sure I will pass that on
If
to
you
the
see her.
individual, even though I think you just did.
Yeah, thank you very much, sir. Chairman Cole?
No questions, Mr. Chairman. I just want to, I always like to acknowledge my friend and distinguished chairman and classmate when he comes up here. Thank you for bringing this. As you pointed out, we're very familiar with it, but it has life this time. So I'm not only familiar with it, but excited by it. I thank my friend for his hard work in this area. Yield back.
Chairman yields back. The gentleman from Florida does not seek time. Is there any other member that would seek time? Gentleman from the state of Washington, Mr. Newhouse.
Thank you, Mr. Chairman. I just didn't want to let the opportunity go by to compliment the good chairman of the Natural Resources Committee. I would hope that you would have time to come by as we consider the rule on the floor tomorrow. Your compelling arguments would be very welcome. I think it's important to, all the arguments that you made underscore the reason I think that no fewer than 11 states withdrew from the rulemaking process because they essentially weren't being listened to, weren't allowed to participate. And so I think it's incumbent upon us to follow through with this resolution, and I appreciate you being here to do that.
Yeah, and amongst the almost 70 co-sponsors so far, you also have encouragement from at least 14 state attorneys generals who are actually also asking this kind of activity.
Yeah.
But I'll be happy to do that, except once you've been in Wenatchee, Washington, I think everything else is kind of a downer after that, isn't it?
I appreciate that. It is difficult, but you're more than welcome to come. So, but with that, Mr. Chairman, I certainly
Thank you very much.
That may
Gentleman
take-
yields back his time. Is there any other members seek time? The gentlewoman from Wyoming, Mrs. Cheney.
Thank you, Mr. Chairman, and Chairman Bishop, I want to thank you as well for this tremendously important effort and the relief it's going to provide across the West, across the country, but in particular in my home state of Wyoming. And as we talk about the burden of regulation, this rule is a perfect example. As you know, back in 2011, a number of state DEQs, including ours in Wyoming, agreed to participate, agreed to cooperating agency status with OSM. The director of the Wyoming DEQ has pointed out that it was then 4 years until they heard back from OSM again. So the notion that we're going to hear, I'm sure repeatedly up here, that somehow these rules and regulations have been the product of tremendous input from the public and input from the people whom they affect most simply isn't borne out by the facts. So I'm very grateful for your effort on this. I think, and I'm also very honored to be part of being able to begin to provide some relief, particularly to our coal industry and to fossil fuels in general. So thank you very much. I yield back.
Gentlewoman yields back her time. Is there any other members seek time with the gentleman? No questions. Mr. Chairman, I want to thank you for taking time to be with us. Congratulations on not only a new era that will take place from your committee that will be able to move forth things, but a chance for so many people to reclaim their right to proper utilization of the nation's resources and the land which they know better than any federal government.
That's kind of you, Chairman. This is clearly the proper thing to do, and I expect to be back here again soon.
Well, I appreciate it, sir, and thank you very much. If you please make sure you leave anything you brought in writing for the awesome stenographer, we appreciate it. Is there any other member that would seek to give testimony to H.J.Res 38? Seeing none, this now closes the hearing portion of this hearing today. And the close the hearing portion of the chair now being received a motion from the gentlewoman from Oklahoma, Chairman Cole.
Gentleman. Mr. Chairman, I move the committee grant H.J.Res 38 disapproving the rule submitted by the Department of the Interior known as the Stream Protection Rule, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Natural Resources. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. Finally, the rule provides one motion to recommit.
Thank you very much. You've now heard the motion from the gentleman from Oklahoma on the first rule. So we will move through. Is there amendment or discussion? No amendment or discussion. Those in favor of the motion signify by saying aye. Those opposed, no. The ayes have it. The ayes have it. Accordingly, Mr. Newhouse will be handling this first rule, rule number 1, H.J.Res 38, for Republicans.
And I will for
And
the
the gentleman from
Democrats, Mr.
Florida,
Chairman.
Judge Hastings, will be handling this for Democrats. Chair will now be in receipt of a motion from the gentleman from Oklahoma.
Mr. Chairman, I move that the committee grant H.J.Res 41, providing for congressional disapproval under Chapter 8 of Title 5 of the United States Code of a rule submitted by the Securities and Exchange Commission relating to the disclosure of payments by resource extraction issuers, a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides one motion to recommit. Section 2 of the rule provides for the consideration of H.J.Res 40, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Social Security Administration relating to the implementation of the NICS Improvement Amendment Act of 2007 under a closed rule. The rule provides 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary or their respective designees. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. Finally, the rule provides one motion to recommit.
Thank you very much. You've now heard the motion from the gentleman from Oklahoma. Is there amendment or discussion to that? Seeing none, the vote will now be on the motion. Those in favor signify by saying aye. Those opposed, no. The ayes have it, the ayes have it. Accordingly, the gentleman, Mr. Buck from Colorado, will be handling this rule.
And Mr. McGovern for the Democrats, Mr. Chairman.
And Mr. McGovern for Democrats, I want to thank you very much. I would like to now proceed with a designation of a vice chair of the Rules Committee. The minority has been provided with this information. I want to thank them very much for allowing this. We will proceed with the designation of a vice chairman. Clause 2D of Rule 11, adopted by the House, provides that the subcommittee chair designate a vice chair to act on his behalf during temporary absence. Pursuant to this rule, I designate the Honorable Tom Cole as vice chair of the Committee on Rules. Thank you very much. And is there any? You know what? The gentleman's recognized for an hour.
Well, my friend, I think my friend should look at the lineup over here and realize I'm the best you're going to get.
You know, Judge, it is amazing how this happens. Tom, how long have you been serving on this committee?
This would be, well, what, 6, 8 years now.
6 or 8 years. We've had really an opportunity to have a number of our members to do very well here. We've had the gentleman from Georgia be the subcommittee chairman of this committee. We have the gentleman, Dr. Burgess, who's a subcommittee chairman for Health at Energy and Commerce. We have the gentleman, Mr. Collins, who will be a subcommittee chair in the Rules Committee. We have the gentleman, Mr. Byrne, who accepted a subcommittee chairmanship under the former member of this committee, the vice chair, Virginia Fox. What is that title of the subcommittee you will have? Workforce Protections. Then we had Mr. Newhouse, who had a chance to take a new job in appropriations. Then we had the gentleman, Mr. Buck, who got a big promotion to come to the Rules Committee. And then Mrs. Cheney just couldn't wait to be here. And by the way, I'd like to, if I could, raise a glass again. Her father turns 76 today, the former Vice President of the United States of America, Dick Cheney, and happy birthday, Mr. Vice President. In your honor, we shall toast the water. This finished. You know what, that's a very good question, and the answer is yes. The next meeting is scheduled for tomorrow. That's Tuesday, 3:30 p.m. We'll meet on H.J.Res 36, BLM methane, and H.J.Res 37, blacklisting CRA. So thank you for the question. We intend to be here. We'll be on time, 3:30. This now finishes our work for the day.